Okay, great. Let's begin. So again, good afternoon. My name is Peter Neufeld. You may have seen me before. If you've attended these Lunch and Learn seminars in the past, I'm a partner at the firm Wagner Sidlofsky. I'm also a co-chair for this Lunch and Learn series. We're about halfway through the series now on will challenges. The other co-chair is David Friedman, who's a professor at Queen's University. The subtopic that we're going to be talking about today is limitation periods. Of course, always a critical piece of information for anyone who's dealing with estates law. A blog was prepared in advance of today's seminar, and that's going to be posted and can be found in the Zoom link if you want to check it out if you haven't already. A few housekeeping notes as usual. Make sure your microphones are off and that they're muted at all times, unless, of course, you're going to be asking a question, turn it on, and then when you're done asking the question, remember to turn it off. Please note that this seminar is being recorded. We've got two presenters today. David Wagner is a partner at Wagner Sidlofsky. He practices in the estate and commercial litigation group. He'll be joined by Harkert Singh Dada, who also practices at Wagner Sidlofsky's commercial and estate litigation group. He's an associate at the firm. They both are excellent estate litigators, and frankly, they're much better basketball players than I am. So I appreciate that they're attending today. Big thanks to our sponsors. We've got the B'nai B'rith, of course, Concentra Trust, Scotia Wealth Management, Torkin Mains, TD, and BMO Trusts and Estates. As you know, this event is complimentary, and it's because of them. So we thank them for that. If you've enjoyed this seminar so far, please consider donating to the B'nai B'rith Canada Food Program if you haven't already. The link for that will be put in the chat. I'll ask Maddie to include that. We've got Richard Robertson, I believe, is here with us today. He's a research manager at B'nai B'rith. Richard, if I've got that title wrong, you can correct me. But he's going to tell us a bit about the organization. So Richard, if you're there, you can take it away.
Certainly. Thank you, Peter. The title was most certainly correct. I am B'nai B'rith Canada's research manager, and I've been asked to give you guys a little bit of a short explanation about what we do in my department. So essentially, we do two forms of research: proactive and reactive research involving matters of human rights focused primarily on anti-Semitism. The proactive research involves triaging incidents of hate crimes and anti-Semitism, other forms of human rights issues that we discover either on social media or through our databasing. We also take part in reactive research where members of the general public reach out to us. We operate in a hotline, we operate an app. We also receive tips from the media, sometimes from law enforcement or other authorities, and then we engage our research process through that way. I've been asked to share a couple examples of how this process works with you. Since it is Pride Month, one of the examples that I will be sharing with you was last year in June of 2022 through our proactive research. So actually through our online social media monitoring, one of the groups that we monitor, the ISUPK, they're an anti-Semitic, homophobic, and misogynistic group. We came to understand that they would be coming to Canada, and that one of their main reasons for coming to Canada, they're primarily based in the United States, would be to interfere with the upcoming Pride March. As a result of our proactive social media monitoring, we were able to put a brief together. We were able to share that brief with Canadian Border Service agents, with the organizers of Toronto's Pride festivities, and as well with the media to alert the general public. As a result of this, issues were taken at the border when members of the ISUPK were able to or attempted to cross, although some of them were able to cross into Canada. Pride was able to proactively combat against any interference, and the media, in a piece written by Joe Warmington, was able to alert the general public in Toronto to the threat of the ISUPK. This is an example of how our proactive research at B'nai B'rith Canada can lead to a real-world result where members of the community, various minority communities, were able to proactively confront a potential hate crime from occurring. As well, more recently, through our proactive social media monitoring, we found out that someone who we consider to be a radical, an American, he's also a comedian by the name of Amr Zar, was coming to Canada. This happened just late last month. for a string of comedy shows. Amr Zar in 2017 made comments where he openly praised Hezbollah and Hamas. These are listed terrorist organizations here. He was set to perform at a municipal venue in London. Thanks to our proactive social media monitoring and our research, we were able to prepare a brief that allowed the London Public Library and the City of London to proactively assess and to prepare for the upcoming appearance of Mr. Zar. So these are just a few examples of how through our research initiatives here at B'nai B'rith in the department that I had, we are able to confront potential problematic issues that impact not just the Canadian society and the Jewish community in Canada and deal with anti-Semitism, but have the potential to impact our larger society here in Canada. And that's all for me. Thank you very much, Peter.
Thank you so much for that. Again, it's a worthwhile cause. I really encourage you to contribute to provide a donation. There will be a link in the chat to do that if you're interested. Okay, so let's start with the seminar. Harcourt's going to begin talking about limitation periods in will challenges. So take it away, Harcourt.
Thank you, Peter, and good afternoon, and thank you everyone for joining us today. As Peter said, my name is Harcourt Singh Dada, and along with David Wagner, we will be discussing limitation periods in will challenges. Jumping right into it, in some cases, when commencing a will challenge, there may be a temptation to delay commencing the proceedings. Litigation over family members' disputes invariably causes tension between the family members and the relatives, and commencing a will challenge, as you know, typically requires the objector to name the estate's beneficiaries as respondents, which means that technically they are suing their family members. As a result, there is often hope that by trying to settle the estate dispute rather than litigating it and trying to achieve those negotiations prior to commencing the lawsuit, the familiar relationship can be preserved. Unfortunately, courts are not sympathetic to these soft considerations to delaying litigation. Accordingly, missing a limitation period can have devastating consequences on a party's claim. An important consideration at the outset when it comes to the limitation period is determining whether the party is commencing a claim and are seeking declaratory or consequential relief. If a party is seeking consequential relief after the expiration of the 2-year limitation period, the proceeding will be considered to be statute barred and the application can and will be dismissed. If, however, a party seeks declaratory relief, then the basic 2-year limitation period will not apply. In our presentation today, David Wagner and I will very briefly review the basic limitation period in estate litigation and highlight the case law, then the key principles surrounding consequential and declaratory relief, and finally share our thoughts on why the real world consequences that flow from declaratory relief are not considered to be consequential in the eyes of the law. So in Ontario, the Limitations Act provides a basic 2-year limitation period, meaning that a claim must be brought within 2 years from the date on which it is discovered. Following the 2-year period, most actions will be considered statute barred and thus dismissed from court. In estate litigation, some courts have found that the 2-year period generally commences from the date of the death of the deceased, subject to discoverability. A case that shows this is Leibel v. Leibel, 2014 ONSC 4516, in which the Ontario Superior Court found that an application commenced more than 2 years from the date of death of the deceased was statute barred. In this case, the deceased, Eleanor Leibel, died on June 4th, 2011, leaving a primary and secondary will dated April 9th, 2011. More than 2 years later, on September 5th, 2013, the applicant Blake, who was the deceased's son, commenced an application challenging the wills. The court found that the limitation period began to run at the date of death. The court found that by September 2013, the applicant decided that he did not receive enough benefit under the 2011 wills, and he did not want to share with the other beneficiaries, so he launched his application. In making this ruling, the court commented that to allow a next of kin to have an innate right to bring a will challenge at any time, as long as there are assets in the estate that are undistributed, would put all estate trustees at peril of being sued at any time. Therefore, the 2-year limitation period generally commences on the date of death of the deceased. Now, what happens after that 2-year limitation period is gone and you bring your application? I'll now discuss consequential relief. The application of the basic 2-year limitation period also applies when an applicant is seeking consequential relief. Relief refers to orders that the applicants are asking the court to award them in their applications. These can include, but aren't limited to, things like the payment of damages, requests for injunctions, awards of support, and things of the like. In these types of cases, courts have found that the applicants are requesting consequential relief from the court. That is to say that the applicants are asking the court to be awarded something that they do not already have, such as a benefit, a right to a property, and those sorts of things. And therefore, it is said to be consequential relief. For consequential relief, the limitation period of 2 years applies. A recent case of the Ontario Superior Court will clarify this principle. In Bristol v. Bristol, 2020 ONSC 1684, a respondent's motion to dismiss an application on the grounds that it was statute barred was granted. In this case, Elizabeth Bristol, the deceased, passed away on December 6, 2016. The deceased had 10 children. The applicant was the deceased's daughter, and the respondent was the deceased's son. The applicant issued a notice of objection on December 30th, 2016, on behalf of herself and 4 of her other siblings, to the respondent being issued a certificate of appointment of a state trustee with a will. The notice of objection stated that the objectors objected to the issuance of a certificate of appointment to the respondent on 3 grounds. 1, that the deceased lacked testamentary capacity and mental capacity at the time she executed her will, which appointed the respondent as the estate trustee and sole beneficiary of the estate. 2, was under the influence of the respondent, and the deceased made dramatic changes to her previous will by removing her other 9 children from the will. And 3, there was no provision in the will made for dependents. So the respondent hired a lawyer to assist him with the probate process. He signed an application for certificate of appointment of a state trustee with a will on January 29th, 2017. On April 21st, 2017, the registrar issued a notice that objection had been filed. The registrar then issued a notice to the objector on July 18th, 2017. The applicant filed a notice of appearance in response on July 25th, 2017, in which she indicated that she had a desire to oppose the issuing of a certificate of appointment of a state trustee for the reasons that were set out in the notice of objection. Now, during this period of time and all the way up until April of 2019, the applicant did not have counsel on the record. The applicant's sister, Cheryl Bristol, swore an affidavit on September 10th, 2019. During her cross-examination on the affidavit, Ms. Bristol deposed that she and her sister, the applicant, and their brother, David, went to see a lawyer in December 2016 who prepared the notice of objection, but that he was not retained beyond that. The court then considered whether any of the steps that took place in 2017 were considered to be a proceeding within the meaning of the Limitations Act. It is clear from the Rules of Civil Procedure in Rule 1.03 that a proceeding is defined as either an action or an application. An application includes a notice of application, which would include a notice of application for appointment of a state trustee with a will. An issue then arises as to whether the notice of objection that was filed on December 30th, 2016, or the subsequent notice of appearance filed by the applicant is defined as a proceeding within the rules. The court in this case found that neither of those documents qualified as a proceeding for the following reasons. First, the notice of appearance is required to be filed under Rule 75.035. If the applicant had not filed a notice of appearance within 20 days of receiving the notice of objector, the court could proceed as if the notice of objection had not been filed. So the court found that such a filing was intended to preserve the status of the notice of objection, but does not create a proceeding under the Limitations Act. Second, the court accepted the respondent's argument that the notice of objection is a form of a caveat, The court cited the case of Ree McDevitt. The court confirmed that a caution or a caveat may stop probate or administration from happening without notice to or knowledge if the person who enters it. A caveat being lodged, a warning should follow. And then if the person who lodged the caveat really intends to contest, he should cause an appearance to be entered. Even then, I do not say that the entering of an appearance would be instituting proceedings to set aside the will. So the court found that simply taking those processes were not a proceeding within the meaning of a Limitations Act. The applicant tried to rely on the fact that she was self-represented as a defense. The applicant insisted that because she was self-represented and because the respondent had taken no steps, she was forced to bring a motion for directions in April of 2019. It was only on the motion date that she learned that she was required to actually issue an application. Now, while all of this is unfortunate, it does not permit the applicant to escape the presumption under the Limitations Act. Bringing a motion for directions is not a proceeding and cannot retroactively cure the applicant's timing problem. Of note, the court found that the motion for directions itself was also brought outside of the limitation period. The applicant's evidence was that she was waiting for her brother, the respondent, to take steps in the probate proceeding. When he did not, she brought a motion for directions on April 23rd, 2019. She sought direction from the court as to what steps she should take. The court indicated that the applicant should issue her application, but without prejudice to the respondent, bringing a motion to dismiss on the grounds that the application was statute barred. In response to the applicant's motion, the respondent did bring a motion saying that the application was statute barred. The court sided with the respondent. In dismissing the applicant's motion for directions, the court found that the limitation period began to run at the date of death. The court stated that the applicant knew or ought to have known that the respondent took steps to be appointed as the executor and estate trustee, and that the applicant herself had taken steps to prevent that from happening by issuing the notice of objection. Therefore, since the limitation period began to run on December 6, 2016, being the date of death, and the applicant's motion commenced on April 23, 2019, more than 2 years later, it was statute barred. In providing this ruling, the court commented also on whether the applicant's motion sought consequential or declaratory relief. The applicant tried to argue that her motion sought declaratory relief pursuant to Section 16 of the Limitations Act, and therefore the 2-year limitation period did not apply. However, the court disagreed with the applicant and found that her motion actually sought consequential relief. The applicant's relief was found to be consequential in nature for 3 reasons. First, the applicant sought the removal of the respondent as the estate trustee and asked the court to substitute herself as the estate trustee. Second, the applicant sought an accounting of the estate's assets and debts. And third, the applicant sought indemnity for unreasonable expenses. The court found that the applicant was attempting to avoid the consequences of the Limitations Act by framing her relief as declaratory rather than consequential. Furthermore, the court stated that challenges to wills cannot simply be framed as declaratory and then found as such. Cases that require threshold tests, that require the weighing of evidence, are not going to be found to be declaratory. Challenges to wills cannot be framed as declaratory since the threshold test requiring the weighing of evidence must be met before such findings can be made. Bristol demonstrates that a proceeding past the 2-year limitation period will not be allowed to proceed just because a claimant or applicant frames their relief as declaratory as opposed to consequential. If the party is seeking anything from the court that requires the application of a legal test, the weighing of evidence, it is unlikely that the court will accept such a proceeding as declaratory. As such, it's important to note that instead of trying to find loopholes after the fact, a party must be vigilant in the pursuit of claims, because as Bristol illustrates, you might end up losing your right to pursue a proceeding and obtain the relief you are seeking. However, as the case below will demonstrate, if a party is truly seeking declaratory relief, then no limitation period will apply and the relief sought will be granted. I'll turn it over now to David Wagner to discuss this issue further.
Hi, everyone. As some of you may know, I'm a partner at Wagner Sadlowski, and as LinkedIn reminded me recently, I've been doing this for about 10 years. I do a lot of work in the estate litigation area, as well as guardianship and elder law disputes, and I also do a lot of estate administration work. So Harcourt has done a great job explaining the notion of consequential relief and how limitation periods apply in that context. And before I go into the real meat and potatoes of what I'm going to talk about today, I just wanted to make a couple of preliminary comments. For the estate litigators out there, I think it's really just important to emphasize that if you have a choice, you should commence an application or a will challenge, whether it be by action or application, within 2 years of the date of death. That is your safest option by any stretch. The other preliminary comment I wanted to make is I hear it a lot from clients and potential clients about hesitation. Harcourt mentioned the fact that there is oftentimes clients are hesitant to commence an application because it is a family dispute. Although it's not family law, it's estate law, it is a dispute amongst family oftentimes. And I will never pressure a client or a potential client to take steps that they're not comfortable with. But what I say to them, and most of the time this works and they listen to me, and I would distinguish this, by the way, from estate litigators versus estate lawyers, like will drafters and lawyers who assist in administration, because I think it's a different calculus. But what I say to them is, if you're calling me, that ship has sailed. The opportunity for you guys to resolve it on your own is gone. You wouldn't have called me if there really was a real shot at making that happen. And my involvement is not going to change that status quo unless we do something, unless we show that we're serious, that we will be challenging a will. So I will never pressure the client to actually do that. And on occasion, I do have clients who say, okay, I'd still like to have another shot talking to my sister or my brother. And they do. And inevitably they come back, whether it be a week later, a month later, or several months later, and they do end up retaining us and moving forward. So what I'd like to speak about today, and what I've been asked to speak about today, is declaratory relief and the application of limitation periods. And to be honest, the distinction between consequential relief and declaratory relief is something that I've personally struggled to wrap my head around. And I don't think I'm alone in that. The case law is all over the place. I mean, you have Bristol versus Bristol that Harcourt just took you through, where it says that a will challenge cannot just be framed as declaratory relief and then to avoid the limitation period. But then you have Justice Dietrich's decision, which we're going to get to in a little bit, where a will challenge, a pure will challenge, is considered declaratory relief. So how do we make that distinction between what is actually characterized as declaratory relief versus consequential relief? And for me, one of the reasons that I think I found it difficult to understand the difference is not about the definition of the terms, but the difficulty lies in how we apply those terms to any particular set of facts. And what I struggled with, at least at the beginning, was looking at a set of facts and determining whether the relief being sought was consequential or declaratory in nature. Let's start with the definitions, and then we can move into how it applies to particular instances and why there's this confusion, or why I think at least that there's this confusion. A declaratory judgment is defined as a formal statement by a court pronouncing upon the existence or non-existence of a legal state of affairs. It is restricted to a pronunciation of the party's rights. So based on that definition, I think it's fair to argue that all will challenges, and I'm referring to pure will challenges, would seem to fall within that definition and the category of declaratory relief. But we know that's not the case. If you talk to estate litigators and you ask them what the limitation period is for a will challenge, I'll bet you that the vast majority of them will respond 2 years from the date of death. And although that's not covering all the nuances and it may not be a technically correct answer, the vast majority of the time it is the correct answer. And it's certainly the correct answer from a practical approach. Like I said at the beginning, if you have a client who comes to you a day before the 2-year anniversary of the date of death, you do whatever you need to do to get that application or that action started, because you don't want to risk having the 2-year limitation period from the date of death. But to understand whether something is declaratory or consequential in nature, I think it's helpful to look at the McMurtry decision, because there are some comments in there by Justice Cawthorn that are really helpful. And one of them is a test. And in that case, the test referred to for determining whether relief is declaratory or consequential is to ask the following question. If the court granted the declaration that's being sought and the defendant resisted the implementation of the declaration, could the plaintiff leave the court in peace and enjoy the benefits of the declaration without further resort to the judicial process? So if we apply that to a will challenge, for example, if the will challenge is successful and the judge declares that a prior will is valid, then the executor under that prior will can go with that court order and apply for a certificate of appointment, which I understand why you could interpret that as being part of the judicial process, but it's not, and I'll explain why in a minute. But the will is valid without any further recourse to the judicial process. But there's another helpful comment in the McMurtry decision that I think it's important to underscore. And it's what helped me really understand why I found it so confusing and difficult to distinguish between declaratory and consequential relief. And I'm referring to the comment that the legal consequences which naturally flow from a declaration which pronounces on a legal position do not constitute consequential relief. So just to repeat that again, the legal consequences which naturally flow from a declaration which pronounces on a legal position do not constitute consequential relief. So what I'm going to do first is I'm going to apply that back to that example of a will challenge. I said earlier, you don't need recourse to the judicial process in order for the will challenge to be effective, for that prior will to be the valid last will and testament, and that's true. But as many of you know, most likely it will be necessary to apply for a certificate of appointment based on that prior will. So arguably, you do need that consequential relief. But it's not consequential relief in and of itself. It is a legal consequence that flows from the declaratory relief. So applying it to that example is really helpful in understanding that nuanced difference. But it also, to me, highlighted why I think it's hard for people to fully appreciate whether particular relief is declaratory or consequential. And that is because sometimes, or oftentimes, I think that people are looking globally at what has to happen should the relief be granted. And they're looking at those legal consequences that flow from the legal declaration. And they're assuming they're treating it all as one thing, as opposed to legal consequences flowing from the legal declaration. So there is a difference between a legal declaration that leads to and has the effect of giving rise to legal consequences versus consequential relief in and of itself. And recognizing that, in my view, is the first step to being able to properly distinguish whether the relief being sought is consequential and declaratory. And this is, again, something that Justice Dietrich highlights in Picut versus Romoli, which I'm sure I didn't pronounce correctly, which is a Superior Court decision and was affirmed by the Court of Appeal. And for those of you who don't know, Justice Dietrich is a judge who sits on the estates list in Toronto and has a lot of experience in estate litigation matters and estate administration matters. So I don't have that much more time to speak to you today, and we want to leave time for questions for people to ask, and I'm sure there will be questions because it is somewhat of a confusing topic. So I'll leave the facts that are at issue in that decision by Justice Dietrich for you to review. They're all set out in the paper that we wrote. But I do think it's important to underscore one element of the decision, which is, in my view, very helpful, again, in understanding whether will challenge in any particular circumstance is going to be declaratory or consequential in terms of the relief in nature. oftentimes you'll get people who are quoting Justice Dietrich's decision just as a categorical decision saying that there are no limitation periods when it comes to will challenges. And I think that that's a mistake. And I think Justice Dietrich herself would say that that's a mistake. It's far more nuanced than that. At paragraph 45 of the decision, Her Honor distinguishes 3 other cases. She distinguishes the Leibel decision, the Burtsu decision, and the Shannon decision. And all 3 of those decisions found that the limitation period does apply subject to the discoverability principle. But she explains why the limitation period does not apply in the particular case of, given the facts of the particular case in front of her. And she explains that the relief is considered declaratory in nature because no steps have been taken by the executors and trustees to propound the will in question. And then Her Honor writes, had she, the person propounding the will, brought such an application and had Helen, the person challenging the will, responded to the application with a challenge to the validity of the codicils, the 2-year limitation period, subject to the discoverability rules, would have applied. And to me, that's the nuance part. It's the key element of the decision. Because what it says is, it's not that a limitation period does not apply, and it does not say that a will challenge will always be considered declaratory relief, but rather what it says is that where no steps have been taken by the executors and trustees to propound the will in question, that's when a pure will challenge will be declaratory relief. And that's really an important distinction. What it does is it encourages people to propound a will and not sit on their hands, even if it's not necessary, in their view from an estate administration standpoint. But what I do find interesting is a couple of things. The first is, if you look at what Justice Dietrich says at paragraph 45 of her decision, I think there's a little bit of an ambiguity there. In the first part of paragraph 45, she says that the reason that it's declaratory in nature is because no steps had been taken by the executors and trustees to propound the will. And to me, that reads, and I interpret that as saying, well, if the executors and trustees had taken a step to propound the will, that would be enough, whether that be a probate application, whether that be, or technically it's called an application for the certificate of appointment, or whether that be an application for directions. Whatever that may be, it's the executors and trustees who take that step. And once they take that step, then the 2-year limitation period would apply. The second part of it, though, says that had she brought such an application and had Helen responded to that application. So that seems to apply that it's not enough just to commence the application. At the very least, you would need to give the opportunity to the respondent, to the person who would be opposing the validity of the will, presumably, to respond to the application. Then the 2-year limitation period would apply. And I think that's somewhat of an ambiguity and needs clarity. The other aspect that I think would benefit from additional clarity is what exactly constitutes an action or a step, to use Justice Dietrich's language, that has or had been taken by executors and trustees to propound the will. Is that a probate application? Is it an application for directions? Are there other steps that could be taken that would be considered as a step to propound the will in question? And I don't think that that's 100% clear at the moment. And even if there are additional, I would argue that based on the language in the judgment and based on my experience, that there are other steps that could be taken beyond a probate application or an application for the certificate of appointment that would constitute steps taken to propound a will. But what exactly falls into that category, I think, is still something that would benefit from clarity. And that clarity will come over time. The other aspect of this entire issue, and it's not restricted to Justice Dietrich's decision, that I find particularly interesting, is the interplay between the step being taken that will trigger the 2-year limitation period, but when that 2-year limitation starts and when it expires is not related to when that step has been taken. So if that's confusing, I apologize, but perhaps it's easier to understand and explain through an example. So let's say Joe passes away in January 2023. Well, we know if the limitation period does apply, that subject to discoverability principles, it will apply 2 years from the date of death. So January 2025 is when that limitation period will expire. But what's interesting, at least I find it interesting, maybe most people won't, but I find it interesting, is that whether or not that 2-year limitation period applies at all is whether there have been any steps taken. And it doesn't seem to matter whether those steps were taken a month after the deceased passed away or 6 months after the deceased passed away, again, subject to discoverability principles. So in other words, what we have here is that for the limitation period to apply, a step has to be taken. But once that step has been taken, the 2-year limitation period appears to apply from the date of death, again, subject to discoverability principles. And I find that interplay to be very interesting. It's not something that we normally have. So for example, if you look at a loan, demand obligation, the limitation period will start 2 days from the date that you make a demand on that obligation, or previously 6 years from the date if there's no specific date, but not to get bogged down in that. But it's the request, it's 2 years from the date of the request. And here, what I find interesting is that we have a set start period, which is the date of death. So I'd like to take the opportunity now to open up to any questions that people may have about either declaratory or consequential relief. Harcourt and I are both here to answer any questions.
David, that was a great job, Harcourt, as well. Really interesting. David, from your presentation, the sense I kind of get is that it's almost in a way a policy decision that the Estates Court is factoring in here. They want to make sure that the deceased's testamentary wishes are being followed, but at the same time, they don't want litigants to be sitting on their rights. That may not provide certainty or guidance, but do you think that underlying principle is informing the court's decision on whether they should consider something declaratory and consequential relief, and frankly, why they're even making the distinction for the purposes of a limitation period?
I think that's fair, and I think that there are certainly policy concerns that are at play. I will be in a much better position, though, to respond to that question within the next couple of weeks. I actually just argued a motion before Justice Dietrich, not specifically about the declaratory relief, but the case was that there was an application for directions brought in respect of the validity of a testamentary document, and that was brought in 2020. And the matter came before Justice Dietrich in 2021, and she adjourned the application and requested that the executor provide additional evidence in order for her to make the decision. Fast forward to today, the beneficiaries of one of the testamentary documents alleged or have raised an objection and a purported concern that the document, the testamentary document in question, was not actually in the handwriting of the deceased. So we argued that it's too late. They sat on their hands. If they really had believed that it's not in the handwriting of the deceased, they should have raised that objection initially. And that's the issue before Justice Dietrich. So the way that plays out might answer your question of whether or not it's a policy decision and whether people should be allowed to sit on their hands and sit on their rights before raising an objection like that 4 years after the fact. I'll also note that what the case law does say is that the doctrine of laches and acquiescence can apply in the context of a application for the validity of the will, and the delay will be considered in objecting to a will or challenging a will, even if it isn't statute barred. Because of the court's inquisitorial nature when it comes to will challenges, the court wants to make sure that they have all the evidence before them and that the document actually does properly speak for the deceased. So that's the sort of balance that the court, I think, is trying to make sure is drawn properly. I would say that there certainly is a policy aspect to it, but how that will play out, I think I'll be in a much better position once I get Justice Dietrich's decision back in respect to that motion.
Great. Well, we're looking forward to it. Got one other question. You talked about the discoverability principle a little bit. Let's say that there's, and unfortunately that adds more uncertainty as to when a limitation period expires for a will challenge. Now, let's say there's a will drafting solicitor and they have a client they're preparing a will for, and that client's, pretty worried that there is going to be a will challenge to their will. Is there something that drafting solicitor can do to minimize the impact of any discoverability arguments? So I'm thinking of, sending the will to the beneficiaries before the deceased even passes away. Do you think that's an approach that drafting solicitors should take?
So my first comment would be, if you have a client who is worried about a will challenge, I don't think discoverability would be my primary concern, and addressing and mitigating discoverability issues would be my primary concern. My primary concern would be establishing capacity, ensuring no undue influence, making sure that all those red flags first. If discoverability is really an issue for this client, I think you have to make a judgment call, and it's going to be a case by case basis. I am for the idea of transparent discussions, oftentimes when it comes to wills. I think maybe I'm taking that from the perspective of the litigator, so I see everything that goes wrong all the time. So I have a bias that everything's always going to go wrong all the time, and that's how I approach things. And I realize that that's not necessarily reflective of reality. The vast majority of the wills in existence don't get challenged. So I don't know if it's appropriate for me to comment on whether or not the will should be disclosed to people. I would suggest that be on a case by case basis, but I know that most people do not like to discuss their wills with, especially beneficiaries, before they pass away. What I would recommend, if I were the client were consulting me on that, I would say, once you pass away, we'll give clear directions that the will be disclosed to everyone, and give me the names of who to disclose it to. And if that's the concern, but you don't even have to send the will out. If you're, for example, you're worried about someone who is not included in the will, discovering that they're not included in the will, you can just say that. You don't have to send them a copy of the will.
Great. Thanks, David. If other people have questions, feel free to put them in the chat, or you can ask them orally on Zoom as well.
If anyone has any other questions, I'm more than happy to talk a little bit more about another example I had raised before. While I was during my discussion, I had raised the idea of what exactly is going to constitute a step taken in respect of propounding the will. And I raised the fact that I think that it's an open question, and it requires additional clarity. And I think that that's true. There are cases that we deal with. It's important to note as well that the PQ decision, which is Justice Dietrich's decision, was a 2019 decision that was affirmed by the Court of Appeal in 2020. So it's still a relatively new decision. And in terms of any step taken, I think there are different scenarios that arise. So one of the scenarios that's arisen in my practice recently is we have a case where probate was not applied for. There was no application for the certificate of appointment, but the estate trustee did deal with an action, had commenced an action against the beneficiary, who is now making noise about challenging the will, and on notice to that individual, and commence an action as the executor and estate trustee. Now, is that a step towards propounding the will? I would argue that it is, because the only authority that person would have to commence an action as a estate trustee would be pursuant to the will. And for that to happen, it would be that the will is valid. I don't know whether that argument would succeed or not succeed. I suggest that it should, not just because that person is my client, but because also I think it's the right decision. But ultimately, it doesn't fit within four corners of the argument that it is a step taken towards propounding the will. It's a byproduct of it, because as you may or may not know, most of the time when you commence an action or you continue an action on behalf of the deceased, you should get an order to continue. And while it's not, you may be able to get an order to continue without getting a certificate of appointment. The case law does suggest that a certificate of appointment is necessary and should be necessary in order for you to get an order to continue and to continue that lawsuit on behalf of the deceased. So that's a long way of saying that this is still an open topic, and I think it does require additional consideration.
Well, great, thank you. I'll leave it open again for a little bit if anyone else has any other questions. And if not, then we can wrap up the today's seminar.
I just have a quick question for David and Harcourt. Suppose you are the lawyer who's involved in the administration, and it's just the day before the limitation period expires. What do you do when they come to you the day before it's supposed to expire? What are you supposed to do? You're not a litigator. How do you advise them to proceed?
Sorry, if you represent, if you're an estate administration lawyer and your client wants to challenge the will?
Well, they come to you and say, limitation period is over tomorrow. I haven't made up my mind if I want to proceed. The lawyer has to be concerned about their own negligence if they miss the limitation period. You tell them to issue a claim and hold it in abeyance because you don't have to serve it. What would you do?
I would say call Wagner Sadlowski. That would be my response to it. And I think I don't think you can commence a claim, because if you are the lawyer who drafted the will and the will is being challenged, that obviously puts you in a conflict of interest, not to mention the fact that you should probably also refer the matter to Law Pro and notify Law Pro of it. But I do think, given the timing, that you would have to certainly advise your client to get counsel. I think that to me, the more interesting question is, we know now that the 2-year limitation period, again, subject to discoverability, applies from the date of death. But we also know that to trigger that, you need to take some steps to propound the will. So if you do have a concern, or what I find an interesting sort of gap is, if you do have a concern that someone else, if you're propounding the will and you have a concern that someone else is going to challenge the will, does it make sense after the expiry of the 2-year limitation period to take a step to propound the will? Because by taking that step alone, do you then trigger that 2-year limitation period and prevent anyone from challenging the will? And I don't know the answers to that question. I would say, based on the first half of the paragraph 45 from Justice Dietrich's decision, I would say the answer is that is enough to trigger that limitation period. But based on the second half, it's not, because you didn't give an opportunity for the challenger to respond. So that would be my response to that question.
Another interesting aspect is, if there is a dependence relief application in the weeds, someone is going to challenge as a dependent. It's probably a good idea to start the probate process sooner rather than later. Would you agree?
Well, I do see in the chat that someone's asked about dependent support, so let's talk about that. The question is it not the case that dependence relief claims can be made within 6 months of the date of the issuance of the certificate of appointment of trustee under the will? The answer is yes, that is what the legislation says. I would also mention the fact that there is a further provision that you can get leave to beyond that 6 months of the certificate. But just to be clear, a dependent support or dependent relief application is not a will challenge per se. It's not saying that the will is invalid. It is saying that that there has not been adequate provision for the proper support of you as the dependent. And therefore, I'm not sure that the limitation period in terms of a will challenge would apply. And obviously it doesn't, because it specifically says in the legislation that it's 6 months from the date of death. So to answer your question, I don't think that the applying for the certificate does anything to trigger the limitation period beyond that 6 months from the granting of the certificate of appointment.
Cool. Got another question here about, you know, a potential claim for a drafting solicitor's negligence. The question is if, you know, someone is alleging negligence against the lawyer who drafted the will, whether that would fall inside any of the categories of, you know, consequential or declaratory relief that were discussed. I mean, my take on that would be, I suppose it depends on what the theory of negligence is, but, you know, let's say, for example, a lawyer failed to direct the deceased to comply with the formalities of execution, and this was before the new substantial compliance regime came in, and that will was found to be invalid. You know, I don't think that would be a situation where the limitation period would apply from the date of death when you're considering negligence against a will drafting lawyer. David or Harker, do you have anything to add to that?
Yeah, I would say that the typical limitation period provisions that apply to negligence would apply to that. I don't think that the fact that it has to do with with a will or a drafting of a will has any effect on the limitation period. Now, whether it's declaratory relief or consequential relief, I think will depend on what the negligence is, and it has to be decided on a case-by-case basis. And I don't think you're going to have a clear answer either way if it's on the border of declaratory relief. But I would venture to say that the vast majority of negligence claims would probably be consequential relief.
Mm-hmm. There's another question here about, you know, an estate trustee seeking directions from the court about the sale of an estate asset to pay the deceased death, and the question would be whether that would be consequential relief where the 2-year limitation period would apply. Again, I don't think that it would follow in the framework of is this consequential or declaratory for the purposes of a will challenge. You know, I suppose there's an issue of a limitation period there when you're dealing with, does that claim for that debt, is that past the requisite limitation period? But I think it would be separate from a will challenge. I don't know if the presenters have anything to add to that one.
So in terms of, is the question whether or not the application for directions with respect to the sale of the asset is subject to the limitation period, or whether that would constitute a step taken by executor to propound the will?
I think it's the former. That's my interpretation of the question.
Okay, so a trustee can apply for directions at any point, then that wouldn't be subject to a limitation period. In that sense, it's much like a passing of accounts. You have an ongoing obligation to pass your accounts, so there's no limitation period that applies to that, and no limitation period that applies to a notice of objection. In terms of requesting directions with respect to the sale of an asset, that would be an ongoing obligation, and therefore no limitation period would apply in my view. So I don't see it there. In terms of whether it's a step towards propounding the will, I would argue that it is. I don't know how the court would decide that, because it's not actually a step propounding the will, but it is as a prerequisite for you to bring that application for directions from the court with respect to the sale of the asset. The court would have to accept that you are the estate trustee and that the will is a valid will. In that sense, it's very much like take a mortgage enforcement, right? In order for you to bring an action to sell the property pursuant to mortgage enforcement, there is an underlying assumption that has to be made that the mortgage is a valid mortgage. And the case law establishes that and establishes that res judicata applies. So in very much the same way, I would say that once you bring a proceeding, any proceeding, whether it be an application for directions or a claim or whatever it may be, as an estate trustee or as an executor, that is by its very necessity, by the court allowing that, is a step towards propounding the will.
That same person who asked that question, they've got another question that's, you know, somewhat similar. I think it also would entail an application for directions in this case. It's when one of the beneficiaries die before the testator dies and the estate trustee isn't sure whether that gift to the beneficiary has lapsed, and they may need to bring an application for directions. Would there be a limitation period subject to that?
No.
There's one other question here. I'll read it out. It says, will steps taken by the executors to propound the will include writing to financial institutions and no certificate is being applied for? What possible information would potential beneficiaries have? The last part of that question, it's not completely clear to me, but I think that the question here is, what steps that are taken by executors to propound the will. I guess if they're writing to financial institutions, but no certificate has been applied for, would that consider perhaps a step in propounding the will?
I don't think so, because I don't recall off the top of my head, but the decisions that we go through in the article or the paper that we wrote, one of the decisions talks about how there were steps taken pursuant to the will and distributions made, and that does not convert it from declaratory relief to consequential relief. So acting under the will is not, I don't think, taking a step to propound the will. I don't think that contacting a bank, for example, and saying I am the executor is a step to propound the will. I think it has to be some sort of step within the court process, I would argue, for it to be propounding the will. I would also just note that from my experience, contacting financial institutions with a copy of the will and saying transfer over the account to me is not going to be effective. They will likely insist on a certificate of appointment.
Okay, well, thank you again. Really good presentation, both of you. Thanks so much for that. And thank you all for attending. We really appreciate it. Our next seminar will be about, will be in a couple weeks from now. If you haven't registered for that event, we're going to include a link to do so in the chat. For that, please do not forget there is a certificate of attendance today showing that you've attended and confirming the CPD hours for today. Thank you again for attending, and we look forward to seeing you in a couple of weeks.